Hello, welcome to our webinar on wills, estates, and end-of-life planning. My name is Sarah Sunnucks, and I'm a funeral director here at Smith's Funeral Home in Burlington, Stony Creek, and Grimsby. And I have with me a special guest, Alyson Sweetlove, who is a lawyer with George Street Law. And we're really excited to come this afternoon and just have some really good conversations about wills, estates, taxes, all of that. So for me, wills are definitely a first step when it comes to planning. It's very important here at the funeral home that wills are done and done properly. So a relationship with Alyson was something very important to me to have, just to make sure that with the pre-planning here at Smith's, we make sure families are doing the right steps for their estates and making sure that everyone is doing what they need to do. So that when the time comes and the emotions are high, you already have in place what you need. So how we're going to kind of run the webinar today is I'm going to kind of give some scenarios to Alyson, different family things that we've gone through here at the funeral home, and she's going to give her kind of expertise on how things should look and how best be prepared for these kind of scenarios. And then you are welcome to ask any questions in the chat. We will be having a time for questions at the end. And if your questions do kind of align with what we're chatting about, we will talk about them as well. But definitely we want to hear from you and what you're going through. So all right, so I'm going to start with just thanking you, Alyson, for being on the call today, and hopefully this will be fun for both of us.
Thanks for having me, Sarah. I've missed doing seminars with you guys at Smith's. As you guys know, it's been a part of my profession for the last, gosh, it's got to be about 15 years now. We've been doing these, and I always enjoy them so much. The audience always has such great questions, and I just think that there's so many people out there who just need a little bit of information to make them feel comfortable and to be able to take some steps forward with their estate planning and just get that comfort level, right? That certainty that they have everything that they need in place, that they've done everything that they can to make things easier for their loved ones. So I think that's the big thing that most people are concerned about is not leaving a mess behind. And none of us, I think, intentionally would do that, but it's often that just that lack of understanding or information creates some of those situations. So I'm really looking forward to our discussion today, and hopefully that will help people to get the information that they need to take that next step.
All right. Okay, so scenario number one. So we did have a family who had an adult child, so around my age, and they were renting, and they happened to pass away suddenly. That adult child had a vehicle, and they had a bank account, obviously in only their name, but just a rental property, like an apartment type of thing. And the family came here, did everything they need to do with us. However, once they left the funeral home, they did have quite a hard time, talking to the apartment owner, trying to get into the home, trying to deal with some, last minute banking stuff. So my question to you is, when is the best time to get a will for people?
That's a great question, Sarah, and I'm glad that you asked it, because I think it's been historically thought that, unless you own a home or you've got substantial assets, you don't really need a will. And I think that was probably true in the past. But I think things have changed substantially, even just in the last 20 years that I've been practicing. I have noticed that, and probably, the people listening have noticed that too. It used to be when you go to the bank, you would know the teller. They wouldn't necessarily need to check your ID to do things, or they would know your spouse. And so if you had questions, your husband or your wife said, oh, can you go and ask them about this? They would tell you things because they knew you guys and they were comfortable providing you with that information. But what we've seen is that over the last number of years, the banks and other financial institutions have become more rigorous in terms of their requirements. That's probably, you know, lawsuits and things like that have developed. We're a bit more litigious as a community these days than we ever were before. And so it's really become a situation that as soon as you're an adult, having a will is probably the most important thing that you can do to plan or to make sure that there aren't going to be any issues. If you have, you know, a home and some investment accounts and bank accounts and, you know, yes, we need to administer the estate and you don't have a will, the family gets together, whoever gets together, they decide who should apply to the court to be appointed as the estate trustee, and they get a court order. And a lot of the times people think, well, that's not really a big deal because we're dealing with a lot of stuff. And without a will, if a person doesn't have a lot of assets, you still have to go through that process to get an estate trustee appointed. And that can be relatively expensive compared to the value of assets that we're talking about. And so, you know, conservatively $1,500 to $2,000 to get that court order that appoints somebody as the estate trustee. Whereas if you just had a will in place that names somebody as the executor, that person could then deal with, you know, the rental company about the apartment, figuring out the details of that, you know, when to terminate. Go to the bank. If there's a nominal amount in the bank account, there can often still be arrangements made for the release of those funds. And, you know, filing final income tax returns. Again, as long as you have the will naming you as the executor, you can do those things. So having that will in place can, in fact, in those, you know, small estate situations, save substantially on the cost of the administration. And, you know, if you're looking at a few $1,000s to get that court order versus, you know, maybe under $1,000 to get a will done, it's a pretty easy cost benefit analysis to undertake. And so I think, you know, back to the original question, I think everybody should have a will, and that's not just because I do wills. It's because in practice, what we've seen over the last number of years is that having a will instantly reduces the costs associated with the administration, be it a big estate or a small estate. And the other side of that, which can't quantify in monetary terms, is just that certainty and that comfort level for the family members. Yeah, it's okay, there's a will, we know who they wanted to appoint, we know what they wanted to have happen to whatever their assets are, right? It's clear, there's no chance for people to start arguing, there's no stress involved with what do I do, how do I do this, I've never dealt with a lawyer before, I don't want to have to go and see one, all of those kinds of issues.
For sure. And, you know, when it is a sudden death, there's so much emotions going on. To then add things like, well, we don't know who you are, you need to do this and that, it does make things a lot more difficult for a family. So for sure, everyone needs a will. That should be our slogan.
I agree.
All right, second scenario. So when someone passes away, their first call is usually to us. Our phone number is 24/7, 365. We never take any, you know, holidays and close the doors. We're always available. And when someone calls, our first question is there a will? Who is the executor? And almost everyone says, well, I'm the power of attorney. But to us, that doesn't mean anything. So what does power of attorney mean? And what is the difference between power of attorney and executor?
That's another great question, Sarah. The powers of attorney, these are documents that are created for while you're alive. There are two kinds in Ontario. There's what we call a continuing power of attorney for property, and there's a power of attorney for personal care. The power of attorney for personal care is pretty self-explanatory. It's a document that allows somebody else to make decisions on your behalf regarding healthcare, end-of-life decisions, accommodation, nutrition, hygiene, shelter, all of those sort of personal things, things to do with yourself, your body. Whereas the power of attorney for property, when we say property, we don't just mean real estate, it's anything to do with your assets. And that allows somebody to assist you with the management of your finances and dealing with your assets while you're alive, whether you're capable or ultimately become incapable. But the thing about those documents is they both end at the moment of death. So that power of attorney is really just while you're alive. And then at the moment of death, then the will takes over and whoever's named as the executor starts off. Now, often there's going to be the same person or people in both of those roles, but they are different, and the authority under the power of attorney doesn't continue post-death. So you need to make sure that you've got both sets of documents. I think they're both very important, the powers of attorney while you're alive, to make sure the people you want to be making decisions on your behalf are in fact the ones who end up making those decisions for you, and also the will, so that it's smooth if and when you pass away, but also letting people know who you've appointed so that they do understand that transition between the different roles.
Great, thanks. Yes, power of attorney ends at death, so the funeral home can't help you with that. All right, so this one actually is becoming more and more popular as a problem. So I'm going to use this as a man's experience, because I've been finding it's more the man that goes through this. So a man has been separated from his wife for many years, and he's been living with his girlfriend. So basically common law status, but not officially. So they've been living together, but there's no official documents. The question I get is, the man wants the girlfriend to be in charge of everything. So legally, how does that work?
Yeah, that's something that's becoming more and more common. People find it shocking when I say that you're allowed to have more than one spouse these days in Ontario, and that's because you can have a married spouse that you never formally divorce, and then a common law spouse that has spousal status in certain ways while you're still alive. So in that situation, unfortunately, the world of estates law has made some progress this last year, but it hasn't quite caught up to some of the other areas like family law, when we're talking about support and division of assets and things like that. And so the only way for that individual to ensure that his common law spouse or his current girlfriend, whatever, however they want to define that relationship, either has the ability to act as his representative and or receives anything from his estate is to have a will. So the will would need to name her as the executor, because your executor, not your spouse, not your children, not anybody else, your executor is the one who technically has the authority to make any and all funeral and burial arrangements for you. So again, it's really important that that document's up to date and has the right people that you want in there, doesn't have anybody that you don't want in there anymore. And another sort of wrinkle to that situation, not quite what you asked me, but if you have a married spouse and a common law spouse, and you say, okay, I'm updating my will because I want my common law spouse to be the executor, I want her to get everything from my estate, then you have the situation of the married spouse still having certain rights to your estate. Now, this is where I said they've caught up recently. It used to be that if you were married, regardless of how long you had been separated, your spouse, if you died without a will, was entitled to what they called the preferential share from your estate. So the first, right now, $300,000 of assets, plus a percentage of the balance of your assets, depending on whether or not you have children. They've revised that now to say if you were separated at the time of your death, and separated requires proof and evidence and all of that kind of stuff, then your spouse maybe doesn't have the same rights, but again, only if you have a will. If you don't have a will, your married spouse still has status, your common law spouse has no status. The only thing that they can do is potentially make a claim against your estate. That means suing your estate for support. And so that's not really an ideal situation for anyone, particularly if it's a situation of blended marriages or families and things like that. There can be a lot of tension between children and current common law spouse. So again, a will is the best way to sort that all out and make sure that you're not leaving that kind of a fight or bad feelings or just a general headache and mess for people.
Yeah, we're finding blended families are definitely changing the way estates are being done and funerals are being done and who we listen to and even who gets the Canada pension benefits, right? So yeah. Definitely things to know beforehand, right?
Yeah.
All right. So here in Burlington, we have a lot of retirement homes, and sometimes when someone goes into a retirement home, their first spouse has passed away, and they might find someone new at the retirement home. Now, this is someone that might have their own adult children, their new, partner has their own adult children, and now they're planning to get married. So this will be a marriage later in life.
Mm-hmm.
Yeah. So how do you protect your adult children from still inheriting what you want them to inherit now that you've remarried and there's another spouse with their own family? Because potentially if you happen to pass away first and your new spouse gets everything, your children could potentially not. So how does that happen?
Yeah, absolutely. And with people living longer, there's just going to be more of those sort of second relationships, whether they're formal marriages or again, that common law situation. And there's a number of different things that need to go into that. Obviously, the first one is you have to have a discussion about how you're going to hold your assets, right, while you're alive, and then what's going to happen on your death. If you change the ownership to joint ownership, or if you designate that person as the beneficiary of your RIF or your tax-free savings account or your pension or anything like that, all of those things will pass automatically to that person upon your death. They're not considered part of your estate because they were either joint assets or paid out directly to a named beneficiary. So that's the first thing that we warn people is that, be careful how you set up your assets because that can completely circumvent your will. The second part of that discussion then becomes, and we often see people say, well, but I still want them to get everything. If I go first, I want them to be taken care of. But we've agreed that once we're both gone, this is how whatever's left is going to go. And again, that's wonderful, but once you're gone, they can change their will, right? They can say, yeah, that's what he wanted, but I've changed my mind now. And people get very upset about that, which I understand, but I always remind them again, you don't know what's going to happen between them and your children. Maybe your children are going to be horrible to them once you're gone. I have seen that more times than I care to remember, where, the kids kind of behaved as long as mom or dad was alive, but then once the spouse inherits, they're resentful. I've had calls from kids saying, well, I want her to give me this money. Like she should just give it to me because it was dad's money and she doesn't need it all. And, that's not appropriate. So if you want to make sure that the assets and the disposition happens the way you plan, you need to actually have a contract between the two of you that sets out that neither one of you will change your will without the consent and approval of the other person. And that's either a marriage contract before you get married, if you're going to get married, or a cohabitation agreement when you're just living together. Those agreements can be put in place at any time, but they do require that both parties disclose honestly, openly, and completely what their financial situation is, and that they each get independent legal advice to understand what they're giving up in those circumstances. The other wrinkle that I see when it comes to these things is the fact that if one of the spouses becomes incapable, they can no longer change their will and they can no longer consent to their spouse changing their will. So we've had some situations where the spouses did their wills, did an agreement that said that they won't change their will. One spouse becomes incapable and the other spouse looks at their will and says, well, I need to set up a trust for my wife. I need a new executor because they're not going to be the one who can administer things. Other things have changed and I really need to change my plan, and their hands are tied. So again, not to go too far off the rails on this topic because it's kind of a really complicated one, and it requires people to really talk openly about what their situation is, what their priorities are and their goals are with their estate plan. But essentially what I say to people is if you're concerned that you want your children to receive a minimum amount or a specific asset, you need to either make those gifts outright right off the top in your will, or you need to set up a trust that will hold some of those assets and put parameters around how your spouse can use those during their lifetime, and then directs what happens once your spouse dies. Now, obviously, that's a more complicated estate plan. It requires ongoing administration, so there's going to be increased cost associated with that. So all of those factors have to kind of go into the decision about how we're going to approach this plan. It's definitely becoming more and more prevalent. It's definitely becoming something that I think people need to appreciate, that, again, the costs of putting in the planning are going to be recouped at the end because of how complicated it can get, and because of all the relationships that are involved. You really need to make sure that it's done properly so that everybody has things work out the way they intend.
Yeah, and I think you brought up a really good point. You know, I'm finding that with people living so much longer, their wills, you know, they might have done them in the 90s or the 80s, and the spouses were each other's executors. But by the time one spouse dies, the other parent is not capable of being able to do the executor duties. And so it's difficult for the kids then, because they don't really have the right to, you know, come in and be the executor now unless they get some legal help. So it's true, once you get to a certain age, you know, you might not be able to have that role as an executor, for sure.
Yeah.
To handle.
So it's definitely always, sorry, I apologize.
No, that's okay. Go ahead.
I was just going to say, so that's another point just to mention, is that it's always good to have alternates named in the will, so that, again, if your spouse or whoever your first choice isn't able for whatever reason to act, or just doesn't want to act. We've seen that, you know, I'm in a different place in my life, it's just not appropriate for me to be the executor right now. Then again, you've got it in the document who you would want to step in. There isn't discussion or fighting about who gets that dubious honor of being the new executor.
All right, so I have another scenario for you. So this particular family has an adult child who, they have a form of special needs, we'll say, so just needs a little bit of extra help living with dad. And there's another sibling who, you know, is okay on their feet, doing what they need to do. And dad passes away. And in dad's will, he wants the daughter, who needs a little bit extra help, to stay in the house, but he wants both children to inherit the home. So a lot of questions have come up around who's going to do the repairs on the house, who's going to do the upgrades, you know, who's going to take care of cutting the lawn, you know, all those things about house ownership. So, you know, kind of around the idea of trust, right? What is the trust for when you do have someone who maybe needs some help around your estate?
Yeah, and that's another area where we're seeing more and more of those situations arise. Trusts are absolutely a really great tool to allow you to plan for and put in place the structure for those kinds of things. But again, it is important, like you addressed, that you can't just sort of deal with it at this level. You know, this is what I want, and they'll figure it out between the two of them. Because again, you don't know if they will, you don't know what situation each of those children is going to be in at the time that you actually pass away, or ultimately down the road. You know, if you've got somebody who has some impediments, some impairments that limit their ability to work and earn an income, they may or may not be financially able to cover the costs associated with living in the house. And if, you know, the other sibling who has an interest in the house, like, they've got to make sure that the property taxes get paid, and, you know, otherwise the property could be sold, that it doesn't fall in on their sibling, the roof doesn't fall in or something like that. And so you need to make sure that you've thought about, how do we cover those costs? And you've set aside some money to do that. You know, it's not enough to just say, okay, the house is going to go in trust for the lifetime of my child, or for this many years, and then once they go, we're going to divide the proceeds of sale. There needs to be some money in that trust as well to help cover the costs associated with the property. And so that may require some assistance in terms of, you know, financial projections of what we think the annual costs to run the property are, if there's going to be major expenses or repairs necessary with the property. And so it does need a more fulsome discussion. The other thing to take into account, if you've got somebody that has special needs, is, are they receiving any government assistance? In Ontario, the Disability Support Program provides benefits including income, but also medical, dental, eyewear, assistive devices. Like they cover a lot of other things for these individuals as well, but they also have really stringent requirements on what assets they can hold, how much they can have, what kind of assets they can have. And so you need to make sure that when you're drafting your will, that you're taking into account what can they receive. Am I going to be inadvertently, disentitling them from these government benefits because of the inheritance? And is that really what I want? I've had some people say to me, oh, well, we don't want to worry about that because they're going to get like $500,000 from my estate. And I say, yeah, but if they were getting, I don't know, anywhere from $10,000 to $20,000 a year in income, plus their medications are covered, plus all of these other things. It's often the medications and the other healthcare related things that are truly very, very expensive and can increase substantially in cost. And if you have this money that you can set aside for them, it really should be that backup money, because once they reach age 60, they're not going to qualify for their ODSP benefits anymore. They're just going to be on Canada Pension Plan now, which is substantially reduced. And that's when their costs are going to go up, right? As they age, they're going to have higher costs. So there are ways to craft trust and to draft your will to take into account all of these potential issues. Some of them can be very easily dealt with. I don't want people to be going, oh my gosh, trust, so complicated, so many questions. A lot of the times, I would say probably 8 out of 10 times when I have clients come to me with a beneficiary who's in that situation, we have a very standard trust that we create for them. It's not challenging. It's very easy to draft. It's very easy to understand and to administer. Complies 100% with ODSP's requirements. So there's easy fixes for some of that stuff, but then there's also the ability to tailor things a little bit more depending on what your situation is.
Great. I know personally I have a brother who is on ODSP, and this is a conversation we had, how does he not inherit so that he can keep his benefits, right? So it is an important conversation for sure. Yeah. So the big question. One of my jobs obviously is to sit with families afterwards and apply for the Canada Pension benefits. And usually by the time I sit with a family, they've just gone into the bank, and then the bank has frozen everything. And so they'll come and sit with me and they'll go, well, when mom died, the bank didn't do this. But now that dad has passed away, they're saying that we need to pay tax, or we need to go to the government, or estate administration tax, or probate tax, as they might say, right? So luckily, because I've been able to do seminars with you, I can do kind of a short recap of what all that means, but explain to us why with mom they didn't have to pay tax, and then with dad they do, and how can we maybe better prepare for that sort of scenario?
Yeah, absolutely. And again, this is something that has changed over time, right? Again, it was historically, the banks were a little bit more relaxed about those kinds of things. But what has happened over time, now that we've got bank cards and online banking and things like that, is that there's more risk that when somebody passes away, someone else might be able to access their accounts and may be able to improperly withdraw money or wipe out an account. And so the bank's normal standard operating procedure is if they get notified that somebody's passed away, they will freeze an account. Now, there was an awful period where the banks were doing this when anybody died, even if there was a joint account holder, and they would just freeze it. And then, the spouse is like, but I can't pay my bills. I can't buy groceries. This is my account. And so we would go and yell at the bank. Not really, well, a little bit yell at them.
Your letter. You got a letter from the lawyer.
That's right. But certainly once both spouses have passed away, that is their normal procedure, is to freeze the accounts. Now, they will pay certain expenses from that account, and typically what it would be 1 month of automatic withdrawals that had been previously set up. They'll allow those expenses to go through because they know that the person who passed away set those things up and that they should be taken into account. They will also issue payment for the funeral account. If you haven't already prepaid your funeral account, which is always the best. I mean, and I say this not because I don't get any kickback from SIS or anything, but just if you prepay your funeral, by the time you need it, it's probably going to end up saving you money because of the way that costs go and the fact that the prepaid funerals are going to be guaranteed. That's just my little aside. I recommend it to absolutely everybody because not only does it potentially save you money, it also just alleviates that stress, right? Funerals are expensive. Very few people have in their personal bank account enough cash on hand that they could just pay that out and not feel it in any way, shape, or form. So making those arrangements in advance are good, but if you didn't, taking the account to the bank to be paid out of their account directly, you can do that. But they pretty much won't let you access anything else until you go to the court and get that probate, is what they used to call it. They now call it the Certificate of Appointment of a State Trustee. It's the same thing that probate always was. It's a court order saying this is the person who's been appointed as the executor. You, bank, whoever, you can deal with that person as the proper legal representative of the estate. So in terms of preparing and trying to lessen the impact, it's going to depend. Certainly, I recommend things like beneficiary designations, if at all possible, on things like tax-free savings accounts, life insurance, RRSPs, pensions, all of those things, because again, they don't require that probate from the court. So you can fill out forms, you can give instructions to the bank, and that will be processed relatively quickly, usually in a matter of a few weeks, and that gets cash into the hands of your beneficiaries much quicker. Pre-arranging, prepaying your funeral, that's another great way to take a big chunk, off the worry of how are we going to pay for this. In terms of other things, it's kind of a challenge. We don't typically, I mean, I've heard people say things like, well, I'm just going to put my daughter join on my bank account. So then if I die, she can just go in and she can access the money in my bank account. Well, in the first instance, we're finding that banks will often freeze that account anyways because they're concerned. There is a law that says if you hold a joint account with anybody other than your spouse, unless it's clearly stated in the will or in a separate document that you intend to gift that account, it is considered an estate asset. It will be frozen and it won't be able to be used in the way that you want. And so usually what I say is, like, there's those basic things that you need to pay. If there's estate administration tax, that's the filing fee to get your probate from the court. It can also be paid directly out of the deceased person's assets. So those are sort of the big expensive things that might come up immediately upon death. If there's anything else, we write all the time to credit card companies or to the city or to whomever and say, this person's passed away, we don't have access to their accounts at this time, and we'll pay the account once we have access to it. And, it really bothers all those, really organized souls who have never been late on a payment in their life, and they don't like to incur any interest or anything like that. But you have to keep in mind that most of the rest of the world doesn't operate like that. Lots of people let their accounts get into arrears for, months, and that's okay. And so in the case of an estate, you don't need to panic if there are accounts that are outstanding. That is the normal part of estate administration. But it's just making sure that things are as organized as possible so that people can get that court order, that probate, as quickly as possible, and then get to have access to the bank accounts.
Yeah, and I've had a few people ask me, once one of the parent dies, should I put my name on my mom's house? And I remember you saying, that's an idea. However, once your name is on that person's house, if you ever got divorced or if you ever went through bankruptcy, that would be claimed as part of your, assets. And so, you really want to be careful. You might trust your daughter, but how much is your son-in-law's interest in, what might happen down the road, right? So I always give your advice, which is make sure you know all of the options and what that means for you, because it could potentially make more problems than just paying estate administration tax.
Exactly right. And you know, that's true of any asset that you put somebody on jointly. Once they're on it, they own that asset the same as you. So whether it's a bank account, an investment account, or your home, if they decide that they want to withdraw money from it, put a line of credit on it, or otherwise encumber it with a mortgage or something, they can do that. I actually just, you know, on the matrimonial home or the principal residence, I had a situation just in the last couple of months where dad died. Mom said, well, you know, I'm just going to put both my daughters on title to the house. I didn't do it. Wasn't the lawyer. I came in after the fact. And then mom wanted to sell the house because she decided, you know, I can't do it anymore. One of the daughters was living there and was like, well, I don't want you to sell the house. And she's on title now. And so the only way that they're going to get her to sign off on, like, she needs to sign the listing agreement, she needs to sign the ultimate agreement of purchase and sale, she needs to sign the transfer document. And the only way that they can get her to do that now is with an application to the court for an order forcing the sale of the house. Way more expensive, right? And not to mention what it's doing to the relationship of all the family members at this point in time. In addition to that, in this case, because the individual who went on, one of the individuals, she didn't own her own home. She was living with mom. That was fine. But I've had situations where clients are considering this and I ask them, does your child own a home already? And they say, yes. And I said, okay, so estate administration tax is 1.5% of the estate value in excess of $50,000. So first $50,000, no tax. Anything above $50,000 in value, so if your house was worth $350,000, you would pay a state administration tax, 1.5% on $300,000, right? But if you've got your child on title to your home and you die, from the date that they went on title to your home till the time that the house is ultimately disposed of, any increase in value, that's a capital gain. If it's your principal residence, you don't pay any capital gains tax. If it's not their principal residence, they are going to pay capital gains tax. And capital gains tax is substantially more than 1.5%. So by trying to avoid a state administration tax, you've actually created a whole bunch of income tax that you otherwise wouldn't have had to pay. So again, like you said, Sarah, it's really important to just work through all those situations with somebody who knows and can just guide you, right? Not to get too far off track, I will say, you know, I've had situations where we have added a daughter to bank accounts and title to the house. She lived with him, she was a sole beneficiary. He came to us having been diagnosed with her terminal cancer and said, I only have, you know, 6 weeks to live. Fine, we can do that. Let's do all of these things. When he passed away, there was no estate. It was all owned by his daughter. Easy, no tax, no stress, no anything. But that was very specific, right? And we needed to know all of the circumstances to make sure that was the right decision for them. For other people, there are other things that we can do depending on what they're hoping to achieve.
That's great, though I don't know where you're finding a house for $300,000 these days.
I know, right? This day and age, probably not.
No, but that's right. It is one of those things that you do have to look at the whole situation and not just the tax, right? Like, what does it mean for every aspect of everyone's life, right?
That's right, yeah.
So when when you're trying to think of who should be your executor, what's usually your advice to families when they're trying to decide who should be in charge of all this information, all of this running around banks, you know, selling of the home? Who do you recommend, you know, for that job?
Yeah, so it's always tricky for people to decide what's right for them. And it's not that there is any sort of set criteria as to who is going to be appropriate for that. I start by telling people the executor doesn't need to know how to administer an estate. We wouldn't expect that they would come in and be like, yes, I know all the laws about estates, I know all the steps I'm supposed to do, I'm ready to do it. That's why you have a lawyer, right? That's why they get advice and direction from a lawyer. What you do want from the person is somebody who is responsible, organized, able to deal with lawyers and accountants and real estate agents and all the people that they're going to have to interact with. who's going to remember appointments, who's going to be able to keep notes and records of what they've done, and is going to be able to stay on top of everything, right? It's really that organizational side of things, that diligence, and also has the capacity to deal with an estate administration. If anybody in the audience has acted as an executor, they know how much time and energy can go into being the executor. And not to, you know, discourage anybody, but it's probably the least appreciated job that anybody will ever have. And I have never in my career run across anybody who was appointed once and would want to be appointed a second time. Even with the smoothest estate, the most easygoing thing, it's a big commitment. There's a lot to do. There's a lot of responsibility. The beneficiaries always want their money. They don't understand why it's taking so long. So they have to be good at, you know, communicating, working with the other professionals that they're going to need, and keeping those records and reports. If you've got somebody who, oh, you know, he's an amazing finance guy, but he's out of the country 20 days of every month, that's not the right person, right? If you've got somebody, oh, she's wonderful, she's so sweet, she comes and looks after me every day and visits, but she can't remember, you know, anything to save her life, misses appointments all the time, is constantly missing paperwork, her bills are always late, that's not the person that you want either. And so you have to be really honest with yourself when you're evaluating your potential candidates. Now, I have some people who will appoint one or more children because they say, well, you know, they kind of complement each other's skill sets. You know, one's more organized, the other one's more, you know, financially minded, or whatever the case may be. And that's great. You can obviously appoint more than one person, but again, you need to make sure that those people realistically will get along and play nice when you're not there, to keep an eye on them and keep them in line. You do not have to appoint your children. You do not have to appoint your eldest child. You do not have to appoint all of your children. There's nobody that you have to appoint. You need to choose who's going to be right for you. If you're somebody, and I have these people come into my office quite frequently, that just doesn't have that. There's either no close family or friends that they think that would be able to step into that role, or the people who are close to them, they just know that that's not a good role for them. There is the opportunity to hire professionals to act as estate trustees. Some lawyers will act as estate trustees. Some accountants and financial advisors may, depending on what they're permitted by their company to do. And all of the major banks have trust divisions and offer executor and trustee services. I would just tell people that if you are considering going the route of a professional, you really want to get to the information on what the fees are going to be, because all of the professionals are going to have set fees. Particularly the trust companies, they're going to set out, you know, we charge X percentage on this number of assets. If your assets go up, that percentage usually goes down, but they also usually have a minimum annual fee. And so it's really important to sort of dig into that and figure out, like, how much would that cost my estate, and do I think that that is necessary? And if so, then there you go. That's another opportunity as well.
That's really good advice. You know, who is going to be the right fit for you, right? So I know at the funeral home, the person who is your executor has to make all the choices here if you haven't done that yourself. And a lot of times they don't have any idea if you wanted cremation, scattering, you know, jewelry, fingerprints. Like, there's so much that is now a choice that your executor has, that if you know, take the time to come in ahead of time, it really does save them having to make those choices. And then on top of it, if there isn't a will, and let's say you have, you know, 5 children like I do, all 5 children have an equal say. And, you know, they might know that you wanted burial in a, you know, Catholic mass, but they don't know, they're not agreeing on what picture to use in the obituary, you know, and when all 4 have an equal say, you can imagine how difficult it is for the funeral director to try to figure out what photo we're going to use for this obituary at that, you know, 4 o'clock deadline before the spectator needs it, right? So a will is so important on our end as well, to make sure that we know that the person we're following the wishes of is the person that you trusted to make this decision.
Yeah, and I would even go farther than that, Sarah, and say that when I'm talking to my clients, I'm telling them go and prearrange. Even if you're not prepaying, go and sit down and answer as many questions as you're comfortable answering, because you will know that even if you appointed one person and they have the legal authority, there may be other people in your family who are going to have very strong opinions. And if you've made that decision, then they're going to kind of come off as a jerk to be like, no, we're not going to do what they actually put in place for themselves. Rather than, well, I'm just disagreeing with my sibling or my cousin or whomever, right? And Sarah, you would know this even, much more so than me, that when the family is grieving, when they're dealing with this, because it's all happened so quickly after somebody's passed away, particularly around the funeral and burial, that's all the like immediate issue stuff. Emotions are really high, right? And people don't tend to be their best selves, let's say, in those situations. And so they're looking for, like, I get calls all the time. She said such and such to me, and I'm thinking, okay. And they're incensed. This is the greatest insult to me. Like, how dare they? I'm never speaking to them again, right? Because in that moment, everybody is feeling more sensitive, emotional, hurt, grieving, and they're looking for outlets for them, right? So the more things that you can put in place, whether it's the will or the prearrangement of your funeral, the better, right? The less chance there is for those disagreements to occur, and the more opportunity there is for the family to spend their time, making photo collages or videos of you and going through the pictures and remembering and having those positive feedbacks rather than opportunities for disagreement. So yeah, I can't stress enough, like, and I say this to every one of my clients, consider, if you're comfortable, they'll even come into your home once we're over COVID, to sit down and go through this stuff. You don't have to go to the funeral home, although Smith has beautiful locations, I would go there. But that is a really important step. And I think it really does go hand in hand with the whole plan, right? Because it's just about reducing the opportunity for stress, anxiety, and disagreement in the family, and making sure that things will go as smoothly as possible.
Well, thank you so much for answering all these interesting family scenarios for me today. I really do appreciate your time. I'm going to have our organizer just put up our information for anyone who wants to get in touch with us. Obviously, both Alyson and I are here to help. We're here to help answer questions and just be there for families as they go about. So that's just a quick little screen that you can take of us. And then I'm going to ask the organizer if there are any questions that have come up while we were speaking, if he doesn't mind just asking them now.
Yeah, hi Sarah, it's John running things in the background here. No one's entered any questions yet, but if you are attending and you do have a question, there is a little question box on the right-hand side of your screen. Usually it's on the right-hand side, and it does say questions. So you can type anything you have in there, and I will read it to Alyson and Sarah. Just
That's great. We don't have any questions. That's never happened before.
I know. Usually we have a lot.
I hope we didn't bore people. I hope they didn't fall asleep listening to us, because it's always hard. I like being in front of people. You can tell when they're interested in things, and if I'm rambling on too much, I can change tacks and connect better with people. But certainly don't hesitate if you don't feel like you want to have the question asked now. Feel free. I think both Sarah and I have email addresses up there. That would be the best way to reach me. I am working remotely most of the time, and so getting my voicemails, they are coming through, but it's easier for emails. I will also tell you all that we did a little happy dance at my house when the government announced that we were moving into the open stage, and so we're going away next week. So I will not be around next week. My assistant will still be able to respond to inquiries if people call in or send an email. But if I don't respond to you immediately, please forgive me. We're taking a much needed family vacation and going up north to see some different walls than the ones in my own home.
That's great. Yeah, for sure. And I just want to thank Guaranteed Funeral Deposits for giving us this platform to be able to do this webinar, and John for organizing it behind the scenes. So thank you very much, even though no one can see your face.
Yeah, for sure. And actually, we did get a couple of questions come in just after the fact here. One of the questions is, if you appoint an executor, do they have to accept the appointment?
That's a good question, and the answer is no, they don't. It is not a requirement just because you've named them in the will, because you can do that unilaterally and they might not even know about it. So definitely that raises the point that if you're thinking of naming somebody, you should let them know and maybe just check with them beforehand that they would be okay with taking on that role. As somebody who I know, I'm appointed in probably a dozen family members' wills, I do like to hear before people do it, because I feel like I might end up in a situation where I had to sort of have a flood of these estates hitting me at the same time. So it's always a good idea just to check with them. You don't need to tell them if you've changed your will, but it does help if you remove an executor, that you let them know that they're no longer appointed, so that you don't have dueling executors both trying to give Sarah instructions at the end of the day.
Yeah, especially for people who don't like surprises, that's probably a big one. We got one more that looks like it's probably the last question here. If I booked an appointment to do my will, what should I expect and what should I bring, i.e. documents, information, etc.?
Terrific. Every lawyer is going to be a little bit different in terms of how they approach the estate planning process. The way that I typically start is by sending out a little form to collect information about you. It asks for information about yourself, your spouse if you have one, children if you have one, or grandchildren, general information about your assets, and sets out at the end some questions, things to think about or talk with your spouse about before you come in, so that you can kind of prepare. Typically, if you already have a will or powers of attorney, we would ask you to bring those documents in with you as well, because then we can kind of go through and talk about, what you had, look at the information that you've provided, and I can do some sort of issue spotting, things that I think we should talk about in the context of your estate plan. Because again, it's the same kind of thing as for the executors. I don't expect that the people who come in to see me are going to know all the things that are issues that they need to address in their estate plan. And so the form is designed to collect that information so that I'll be able to identify those and ask further questions of you. And it also saves a lot of time just in me like copying down information that you're providing to me. So typically, that there'll be an initial meeting, whether it's in person, hopefully we're able to start doing more of those soon, via Zoom or FaceTime, or even just over the telephone, where we go through that information, we talk about what your general wishes are, I give some suggestions and advice about how we might structure that. Then typically, if it's not too complicated, we were able to figure out a general framework, we would prepare drafts and send them out to the client to review. If there's any further information that we need, if they weren't sure about something, we would follow up with them on that. And then you sort of go back and forth until the clients are completely satisfied with the documents that have been prepared. And then there's a final meeting to sign. The other thing that I like to remind people is that although we would like to do a will once and never have to think about it again, often, again, because we're living longer, it may need to be updated from time to time. And so more and more now, lawyers like myself, we keep all of our wills electronically as well. So if I get a call from a client, oh, you know what, there's a new grandchild, I gotta make sure that they're in the will, we can easily add their name in, print the document, get it re-signed, and bring it up to date. So it's definitely something that I think of as something that you should look at periodically. Anytime there's births, deaths, marriages, or divorces, those are big clues. You should pull it out and make sure that everybody who should be in your will is in there, and anybody that you don't think should be in there anymore is taken out. But also, if nothing like that happens, we definitely see it at stages as well, right? Kids are young, one kind of plan. kids are now in their 20s or 30s, starting to have their own kids. Maybe we need to get rid of the trust for them and think about trust for grandchildren. And then often, again, you know, I'm getting more and more clients who are in their 90s and well past 100. And so then a lot of them are looking at me and saying, like, look, my kids, like, they're retired, they're fine, they don't need my money. We don't need to pay estate administration tax to transfer assets to them that they're then just going to transfer on to their kids. So maybe we're talking about some charitable giving. We're talking about setting things up so that it goes straight to the grandchildren. So that kind of evolves over time depending on where you are in life. And again, if you've got that good starting place, it's often very easy to just make those tweaks to make sure that it still suits your family and all of their needs and their situations.
Perfect. And actually, just one last one, it looks like, unless one comes in while you're answering this one. What is the average cost of doing your will?
So I'm going to give you my best lawyer answer and say it depends. You will find if you were to call 20 law firms between Toronto and Windsor, that you would get a huge range of quotes. As you may guess, the closer you get to downtown Toronto, the higher those quotes are going to be. And certainly you will also find that depending on the type of practice that the lawyer has, they may also have different pricing. I charge based on the time that it takes to prepare the documents. So I keep track of the time, it's multiplied against my hourly rate, and that determines the cost. Typically, to do a single will and powers of attorney for an individual, it would be somewhere between $600 and $800. For a couple, it's only going to be nominally more as long as their wills and powers of attorney are kind of mirrors of each other, right? Everything to each other, then the same provisions for if we're both gone, that kind of thing. Because again, word processing being what it is, it's not like we're spending that much time drafting that second set of documents. But I would say to people, definitely ask when you're speaking to the lawyer's office how they charge, what they estimate. And if you get quotes that are under $500, I would ask you to then inquire what the lawyer's hourly rate is. Because what I have seen in certain situations is that lawyers will quote low because they don't actually intend to spend any time on the file. They'll have an initial meeting of 20 or 30 minutes with you. They'll just take down what you tell them. They won't get into any of this, you know, discussions about options for reducing taxes or planning or, you know, those kinds of questions that really add value to the estate planning process. And most of your experience will be dealing with an assistant who's actually probably doing most of the drafting. And so I just caution people to be aware of, you know, what the pricing means and to ask those questions, because you are absolutely entitled to ask them. And at the end of the day, you're absolutely entitled to say, I want a breakdown of how you came up with this. I've had people come to me and say, I was charged $10,000 by this lawyer to do a will and powers of attorney, and I can't figure out why. And the reason is because they feel like they can charge you that. And so, you know, you need to be informed. You need to understand what you're agreeing to and how they're going to charge for that. But generally, I would say that you should be looking or expecting anywhere from $500 to $1,500 for a basic estate planning package of wills and powers of attorney, particularly if we're talking spouses. So will for each of you, power of attorney for property for each, power of attorney for personal care for each of you. That would be kind of what I would think would be a general range this day.
Well, thanks so much, Alyson. And those are all the questions, so that's wonderful. And thank you so much for attending our webinar today. I know it's so great to be able to educate people on what they need to know ahead of time, so that hopefully when the time comes, you can have what you need to do in place so people don't have to go through what they, you know, hopefully you'll be able to stop as much as you can ahead of time so that it's more smooth for them at the time. And Alyson, as always, thank you so much for joining me on our little ventures here with our webinar series right now. But I am looking forward to getting back in person with you, hopefully in the upcoming year. So thanks again for joining Smiths here and just being a part of our longevity. So Alyson's, you know, father and grandfather knew Dawn and Dawn's dad. So we're like the third generation here of us getting together. So, but it's so important to have everything set up properly. So yeah, so give us a call, email anytime that you need some questions answered, and take care today.
Thanks, everyone. It's been great to be here. Take care.